Simpson matter. Mr. Simpson is present before the court with his counsel, Mr. Douglas, Mr. Blasier, Mr. Neufeld, Mr. Scheck, people represented by Mr. Darden. Jury is not present. All right, counsel, the record should reflect that yesterday afternoon the court met informally with counsel here in the courtroom. And the court conducted an informal evidentiary proceeding concerning the exhibits that have been offered by the defense so that we could hopefully streamline our proceeding here this morning. All right, are both sides ready to proceed with their evidence lists? Mr. Darden?
Not exactly.
Okay.
As the court is aware, I have some objections to certain specific items. Mr. Goldberg and Mr.
What is it? It's
Clarke.
Hertz and not exactly?
Well,
Yeah.
we need Mr. Goldberg and Mr. Clarke for
Okay.
many of the others. I do have a handful, which I'm ready to discuss on the record.
Well, it would be more helpful to me if we could do these in order,
I would agree.
since I've got them all here and organized in numerical order.
We sent someone upstairs to arouse and get them down.
Well, we're late getting started already as it is.
I was here.
All right, and I noted this morning that the court had not been served with a copy of your writ. Is that an oversight?
I think it's being filed right now. That's me.
All right. Well, Mr. Darden, which of these are you prepared to go forward on? How about the first page? Can we at least get started on the first page? All right, let's start with the first page. Exhibit 1000 and 1001. My understanding, Mr. Douglas, is that has been, both of those are withdrawn by the defense, correct?
Correct.
All right, there's an objection to 1003, which is a photograph of the defendant and his daughter at the reception. It's a 8x10 blow-up. Mr. Darden, my recollection is that you raised the objection to this.
That's correct, Your Honor.
What's your objection?
Same as before, Your Honor. This is a photograph in which the defendant is posing with his daughter. This photograph lacks any degree of trustworthiness or reliability. He is posing for a photographer. And so to suggest to the jury that this photograph is an accurate depiction of the defendant's demeanor throughout the evening of June 12, I would suggest is misleading. Will be misleading to the jury, so there's a 352 objection to that photograph.
Mr. Douglas?
Your Honor, I thought that the prosecution was making a foundational objection, as their papers to me suggested. Clearly, Denise Brown, Tia Gavin, Cato Kalin laid the proper foundation that that photograph fairly and accurately reflected a particular view at that time, what both were wearing. There was an added focus from that picture on Mr. Simpson's hand, confirming that there was no cut on his hand in that picture through Mr. Kalin. I think it is, in fact, admissible.
All right, I think there is an adequate foundation. Clearly, it's a photograph of a father with his daughter at a happy family occasion. I don't think anybody would take it as anything else, but it does have probative value as to the condition of Mr. Simpson's left hand, and it does have some relevance as to what he was wearing that evening. So the objection will be overruled. All right, number 1010. I'm sorry? You may. All right, record should reflect we've been rejoined by Mr. Goldberg. All right, next objection is 1010, which is Officer Risky's report.
Here's the objection to that.
All right, Mr. Douglas?
Your Honor, it was used at page 14195 of the transcript to impeach I'd also argue that it's a statement of a party offered against a party, and for those grounds, there's an exception to the hearsay rule.
Contrary to public opinion, the LAPD is not a party to this lawsuit, and it was used only for impeachment purposes. A small part of it, not in its entirety. Any portion of it that was used for impeachment was read into the record. It is in the record. Counsel can certainly argue that in front of the jury. It is hearsay.
I would also argue, Your Honor, that it has sufficient guarantees of trustworthiness, which is the catch-off exception to the hearsay rule, such since it was, in fact, a report. It could even arguably, although I don't think a proper foundation was made, but clearly there can be no argument that it is a business record. It was prepared at or near the time of the events by one who was charged with that duty for the purposes of accurately reflecting what he saw at that time. I think for all these grounds that under the catch-all exception at least, it would be admissible.
All right. I'll overrule the objection to the extent that it was used, a particular passage, and this was used, that portion that was actually used as a prior inconsistent statement to impeach Officer Risky will be allowed. The remainder, however, the objection is sustained. All right, 10:11, objection to this photograph, which is an outtake from a videotape from the, as I recall, what was it, American Journal?
Yes. Can I look at that photograph?
Sure.
Briefly?
And during the course of our discussions, either counsel may ask to approach to look at the exhibit itself. All right, Mr. Darden. All right. All right, number 1016, page from the LAPD manual.
Yes, I'm now arguing exhibits that were admitted during witnesses that were examined by Ms. Clarke, so I need to take a look.
Let me direct your attention to section 2346. This was a cross-examination of Detective Phillips regarding his obligations to notify the coroner. So the concentration should be on 2346, section 2346. It's about mid-page.
Objection to this document is hearsay, lack of foundation. It is subject to many different interpretations, as I recall from the testimony from the three homicide detectives in this case. It would be misleading.
I think, Your Honor, on transcript page 15011 to 12, Detective Phillips laid an adequate foundation for the introduction of this document. I think it was also used to impeach. It was also used as a business record. I think that all of those, and also, Your Honor, since it is a portion of the police manual, it certainly carries sufficient guarantees of trustworthiness so as to justify another grounds as an exception to the hearsay rule. For those reasons, I'd move for its admission.
All right. It will be admitted, however, only section 2346, excuse me, 238.46 will be admitted. The remainder will be redacted. All right, 1017.
Will the court do the redaction, the clerk, or should I do the redaction? Thank you.
Your exhibit.
Very well.
Mrs. Robertson has enough to do.
I agree.
All right, section 10250, Health and Safety Code.
Same grounds. Page 15018 of the transcript.
All right, the objection will be overruled. However, the court will highlight section 10250 with a yellow highlighter, directing the juror's attention to the portion that is relevant, and I will draw an X through those sections that are not relevant. to their consideration and save you the redaction problems. All right, that objection is overruled. All right, next item is Special Order 21. LAPD Special Order 21.
Same response, Your Honor, on pages 15018 of the transcript. An adequate foundation was laid. It was used to impeach. It certainly is relevant. I think it also qualifies for a business record, and it carries sufficient guarantees of trustworthiness.
I would disagree that it was used to impeach. I think the officers testified they were aware of their obligations.
All right, that objection will be overruled. All right, number 1019 and 1019A, this is the, my recollection, this is the tape-recorded conversation between Detective Heath and, Richard Heath and Detective Phillips.
Yes, Your Honor.
No, Mr. Willis, I'm sorry. Mr. Heath was the second phone call.
I think the transcript involved both conversations as well. If the court will recall, it reflected Mr. Detective Phillips' conversations with the coroner on the first call and also his delayed second call. I think it's very relevant. I think that Phillips was able to authenticate the actual conversation. It certainly goes to his state of mind. It certainly was used to impeach. I'm not sure if the court's practice in terms of which is the real evidence, if the document itself can go in or simply the tape. I'll leave that to the court's discretion.
Mr. Darden?
Consistent with case law, the transcript is not evidence. As for the tape recording itself, it is hearsay. Detective Phillips was here to testify to having placed a phone call to the coroner's office. I don't think it was used to impeach him at all. He told us what he said and what he did and why he did it, and he told us the time frame in which he did those things. This is hearsay, totally, completely hearsay.
All right, my recollection is that it was used as a prior inconsistent statement, so the objection will be overruled. All right, number 1021, statement of Detective Lang.
Your Honor, is the court allowing 19A as well?
Yes.
The transcript is what in there?
Transcript and the tape, but they have to be used together.
Sure.
Transcript isn't evidence.
Court has discretion to require the presence of a transcript of any tape recording.
There has been no attempt to make certain that the transcript is an accurate picture, an accurate comment.
All right, but the court listened to the tape recording, had the transcript at the time it was played in court, and I make that finding now. All right, as to 1021.
Can I look at the document?
Your Honor, that document was used through Mr. Lang to impeach Detective Phillips. As the court will recall, there was the discussion of whether or not Lang had been informed that Mr. Simpson and his wife had been involved in past marital discord, whether or not Phillips had been told by Furman that Furman was aware of that discord and had been at the Simpson home on a prior occasion. Phillips had denied that ever occurring. We then used Lang's statement to impeach him.
And that was read into the record, and the witness was confronted with it, and that is in the record. The police report is it's nevertheless hearsay, Your Honor.
I would appreciate the court's ruling that that portion that was used should be allowed, but the remainder redacted.
Okay, so are we going to have a blank page, and then at the bottom of the page?
I'm sorry?
Are we going to have a page, an 8.5 by 10-inch page, and then at the bottom of that 1 section, and then we can look at that? I think that's more than a little bit unfair. Anything, the witness testifying to this judge in front of the jury. The police report is hearsay.
Given events, Your Honor, that have transpired since the introduction of that document, Mr. Furman's credibility is very important. Whether or not there has been some sort of code of silence is a relevant issue the defense has raised. The fact that Mr. Furman's partner chose not to recall or did not recall a very important aspect which we think led to an argument that there was a rush of judgment. The fact that another detective placed that in his report are all pieces of evidence that are central to the puzzle that we're attempting to create or to demonstrate the code of silence, the rush to judgment, the possibility that others would say things under oath even less than truthful to protect one of their own.
And that would,
Well,
counsel going to ask the jury to speculate to a number of things and paint all police officers with the same brush. And this is hearsay, and it's prejudicial, given the apparent intended use of the document.
I would say, Your Honor, all arguments that we're offering against the prosecution is prejudicial. That's not the test. The test is whether it is unduly prejudicial in light of the probative value. It's very probative that an officer wrote a report conflicting with the statement of another officer. It's very central to a case given things that have transpired since the introduction of this document.
all right, in the second full paragraph, there is a notation that Detective Phillips had advised Van Adder and Lang that Mr. Simpson and Nicole Brown Simpson had been embroiled in previous domestic violence situations, one of which resulted in Mr. Simpson's arrest. That was a statement that was inconsistent with the testimony here in court. Therefore, this second paragraph will be allowed. However, the hearsay objection to the remainder is sustained.
Did the court just read a complete paragraph or just a portion of the paragraph?
I'm going to leave in the complete second paragraph. Second paragraph states as follows: upon arrival at the crime scene, detectives were met by Detective 3 Ron Phillips, West LA Division Homicide Coordinator. Phillips stated that victim Brown was the ex-wife of O.J. Simpson, the well-known athlete-actor. Additionally, Phillips stated that Mr. Simpson and victim 1 had been embroiled in previous domestic violence situations, one of these resulting in the arrest of Mr. Simpson. That's the only relevant portion on this document with regards to that testimony. The remainder will be redacted. All right, 1023, notes of Mark Furman.
Reference was made, Your Honor, on page 15123 and 24. I think they were used to impeach. I think it could be also qualify as a business exception. I believe Detective Furman also adequately authenticated the accuracy of that report. I think it reflects his state of mind. I think it also carries sufficient guarantees of trustworthiness to justify its admissibility.
I'm sorry, what's the hearsay objection to this? I mean, exceptions?
One, Your Honor, it's being offered to reflect not necessarily the truth of the matter asserted, but that certain things were said. It's being offered, Your Honor, to impeach. It's being offered to reflect the state of mind of the writer.
How does it reflect the state of mind?
Because it talks about those things that he observed that he thought were important at the time that he was walking through the crime scene. Also, Your Honor, being offered to establish his frame of mind in terms of what he knew and when he knew it, which we may then use to dispute some of the representations that were made at the time that perhaps there had been a gunshot wound to one of the victims, that there was some uncertainty, or whether there was certainty as to the nature of the actual crime. It's also going to be very important when we attempt to argue the significance of the picture that he is pointing to and what was in his mind at that time.
All right, this one I'll take under submission.
I'm sorry.
This one I'll take under submission. 1023. All right, 1027, which is, this is the freeze frame of Mr. Fung holding a paper bag coming out of the location where Mr. Goldman's body was located. Mr. Rokar appears in the photograph, as does Miss Mazzola and the two corners people. Mr. Darden, are you familiar with this one?
Yes, there's a 352 foundational objection,
I think the foundation was adequately laid by both Phillips. I think Fung was capable of laying the proper foundation. I think it is also self-authenticating. Huh?
Second. That's part of another video that's running on.
Part of another video would be objecting to. Given the nature of the lens used to take that video, which as the court is aware that this telescopic lens tends to condense space and distorts space as well. It will be misleading to the jury. It will give the jury the impression that there are many, many individuals stomping over the crime scene in a very, very, very small area, which is not necessarily the case. As the court may recall, when you looked at that video, you couldn't tell if people were standing on the sidewalk or in the crime scene. It wasn't until we saw other videos that we could actually determine how far and how much distance there actually was between different individuals. It's misleading.
I think the prosecution went through great pains to call other witnesses to attempt to rebut any suggestion that there are a lot of people stomping through the scene. The picture speaks for itself. The arguments of counsel go more to weight than to admissibility. It is in fact self-authenticating. It is not unduly misleading. I think that both sides would be capable to draw whatever conclusions they deem appropriate from the pictures, but certainly given the other testimony of other witnesses, Mr. Darden's concerns are not well taken.
They have never called a witness to explain to this jury the problems with space and distance in this video and in this photograph, Judge. So there's no evidence before the jury that will help them determine what the actual distances are between different objects and different individuals.
If I'm not mistaken, they called the photographer themselves, Your Honor, who took the video from which this was drawn to talk about where he was, how he did it, whatever distortion questions there may have been. So the jury is fully apprised of those concerns.
All right, but the issue that is depicted in this particular photograph, though, is Mr. Fung coming out of the area where Mr. Goldman's body was holding the paper bag. That was the issue, and that's what it depicts. So the objection will be overruled. All right, 1029. This is the two-page fingerprint report.
Can I see that, please?
I think that's in through Aguilar.
Later.
Correct.
It may have been. My recollection is towards the end when we got to Mr. Aguilar. We went through that again.
Correct.
We marked a couple of fingerprint-related documents with Mr. Aguilar.
It may be also 1323.
It is, in fact, 1323. I'd like to keep two different documents together in sequence.
All right, we'll take this one as submission. My inclination is to sustain the objection to this, since it appears also to appear as Defense Exhibit 1323, for which there was no objection.
We'll compare them first round.
So remind me to come back to that one. All right, 1030.
Another document, Your Honor, that was authenticated by Mr. Aguilar. Can I just see that?
All right, let's do this. We have two sets of these fingerprint documents. Let's compare those and see which one is which, so we'll take those up. Mrs. Robertson, remind us to look back at the fingerprint documents. All right, 1031, coroner document. Objection is foundation. Mr. Douglas.
Submitted, Your Honor.
All right, objection sustained. All right, 1036, photograph. Where does this appear in the transcript?
Your Honor, at page 15886 and 87.
And what was the testimony relevant to this?
It focused on the issue of contamination, whether in fact that appeared to be Mr. Goldman's body, whether in fact there appeared to be a glove on the body. It was very central at that time to issues that we were raising as to the integrity of the crime scene, and to show the apparent lax manner in which some of the crime scene and the victims and the bodies and the evidence were handled.
There was no testimony to establish whose gloves they were, how they got on there. This was a photograph that pertained to the point in time when Ratcliffe and Jacoba were taking care of the bodies, and Mr. Golden's body was on a sheet, and there was a pair of plastic gloves on his body. Whether or not that actually proved any contamination or transfer from one body to another was never established or never linked up with any of the appropriate witnesses.
Oh, I think the jury was able to glean from the evidence, Your Honor, that even the prosecution's theory is not that those gloves were left by the killer in the case. Those were gloves that were consistent with the kinds of gloves that we've seen in court, that were worn by the criminalists. They are there on the body after the body has been moved, if I'm not mistaken. The body's on the walkway. Therefore, it's clear, or at least we must give some belief that the jury can extrapolate, that those gloves were placed there by some police official. The fact that no one knows how they were there or would want to own up to why they were there is not surprising.
No, Your Honor, if somebody would own up, if the defense had decided to call those witnesses that would have been appropriate for that foundation, they never did. And they're asking the jury to speculate that something improper was done without having ever called the witness to establish that something improper was done.
Which photo did this come from?
The photograph turned over to us by the prosecution, Your Honor.
It appears to be one of Mr. Rokar's photographs and appears to have a frame stamp on it of 194.
I mean, Your Honor, I don't think that a foundation necessitates us proving whose plastic gloves are shown on Mr. Goldman's body when it's laying on the pavement. I think that the foundation that's necessary for the admissibility of that photograph is that this was a photograph on June 13th, fairly and accurately reflecting the body as it was at some point in time.
All right, what was the page in the transcript?
15886 and 87.
All right, I'll take a look at that.
What volume was that?
I have page numbers, I don't have volumes.
Okay, next one is report of Officer Vasquez, 1042.
Submit it, Your Honor.
I'm sorry?
Submit it.
All right, objection sustained. All right, 1043 is a videotape of the Bundy crime scene. Which videotape is this?
Is this the video done by
We got a
some
half.
TV station?
That narrows it down.
Well, no, actually, It's narrow enough for me. Because I remember,
If we can see 1043A, B, or C, which are clips from that video.
Yeah, that'll tell us which one it is. All right, Ms. Clarke, are you familiar with these?
yes, can I see you around? Thank you.
And Mr. Douglas and Mr. Goldberg, you were part of our conversation yesterday about these videotapes as well. How do we propose to redact these to the portions that were used?
Mr. Harris is currently doing that as we speak, Your Honor. Since he's been present during the play of all of our videos, he's familiar with those scenes that have been played. We will then show them to Mr. Goldberg or whomever upon our conclusion of that tack. As the court will recall, by the way, Your Honor, this was the video where there was a preliminary objection because we didn't know who the photographer was. There was then a 402 hearing with Lang. There were strenuous objections at those times. We had the hearing. Lang laid the foundation. The court overruled the objection, and it was then played for the jury. But attempts had been made much earlier in the trial for this snippet, and then we were able at that point to lay the adequate foundation.
Your Honor, if it's helpful.
And the objection on this is not foundation, the objection is 352, Your Honor. And the problem that was presented, and I think actually the court's in a better position to assess why it's 352 now than it could have been before, having seen all that it has of the actual photographs and of all of the testimony at the crime scene, of the people at the crime scene, and of the testimony of the photographer, videographer that the people called to put the American Journal photograph into perspective, which is this, that this video was actually taken by someone across the street. All of the photographers, according to that testimony, were across the street. They were not allowed to be anywhere near the crime scene. As a result, they had to use a zoom lens. In the use of the zoom, you have a compression of space, making it appear that everybody's on top of each other, crawling all over each other. That's the problem with this video. It's very misleading and confusing, highly prejudicial to the accurate depiction of what was going on at the crime scene and the manner in which it was handled. The stills are actually much better because there isn't nearly as much misleading information. And I think that if the court were to admit the stills to show what they want to show is how were mistakes made in the handling of the crime scene. For example, Rockne looking in the mailbox, someone holding a coffee cup, and Dennis Fung stepping out of the crime scene with a brown bag in his hand and not wearing any gloves. That indicates everything the defense needs in terms of being able to communicate to the jury what mistakes were made in handling the crime scene. Fair enough. And the people would withdraw their objection to 1043A, B, and C. But I think that the video is unduly misleading and confusing because of the manner in which it was shot, and I think that that would be unfair.
All right. Then the people withdraw their objection to 1043A, B, and C. What I will do is ask Mr. Harris to exhibit to me later today 1043, the portion that was shown.
Can I say one thing, Your Honor?
Certainly.
Your Honor, one, these videos were all taken across the street. Those that the defense seeks to introduce, those that the people have already introduced. Two, there was, and I forgot his name now, the African-American gentleman with the balding head who testified because he had been hired as a stringer to take photographs on this day, and there was a major quality of evidence focusing on that very issue. In fact, responding to Ms. Clarke's concerns that there was this element of distortion. Therefore, the arguments that she's made, which parrot those made earlier, simply go to the weight to be given, not to the admissibility of the tape.
But, Mr. Douglas, all I'm saying is, gee, before I finally decide, I'd like to see it one more time.
Very well, Your Honor.
All right.
All right, just for your assistance, I've identified at page 17904.
I'm sorry, Mr. Scheck, I can't hear you.
At page 17904 of the transcript, when the discussion of this begins,
All right.
at least for these segments, the court read out the counter numbers, because these were videotapes that had counter numbers, so I think I'd be able to read it.
All right. All right, the record reflect that exhibits 1044A, 1044, 1044A, 1045, 1046, 1046A have been withdrawn by the defense.
Correct, Your Honor. They all concern the testimony of Rosa Lopez.
All right, also 1048 has been withdrawn.
Correct, Your Honor. That was used only to refresh.
Right, all right, 1052. Hearsay objection.
Your Honor, that was discussed on transcript page 17998 through 18001 concerning an entire area of cross-examination of Detective Lang as to the importance of having a body examined soon. It was used to impeach. It is used as offered as an exception to the hearsay rule.
I need to see it again, Your Honor, but it was my, oh, thank you.
I'm sorry, what was the page reference?
17998 through 18001.
Thank you.
People have no objection to the pages 29 through 38. People object, however, to the last 2 pages or 3 pages offered concerning stomach contents for which Detective Lang could not have been impeached. It would be inappropriate, improper impeachment of him. That's beyond his field of expertise. It has to do with assessment of time of death for stomach contents.
Mr. Douglas, that's probably because that portion was not used with
Your Honor,
Detective Lang.
I don't want to argue its admission.
I'm sorry?
I don't want to argue if its admission if it wasn't used. So
All right. To the extent it was not used.
to the extent it wasn't used, that's fine.
All right. All right, then what we will do is
Well,
sustain the objection to the portion that was not used.
Well, the people would urge the court to sustain the objection even if the portion was used for stomach contents, because it would be improper impeachment, because it's beyond the witness's field of expertise.
Mr. Douglas just acquiesced to that.
I heard him only acquiesce to the part that was not used. I can't remember if it was used with
No,
Detective Lang.
we've agreed that it's just the physical observations made by the investigating officer here at the crime scene has nothing to do with autopsy examination or anything like that.
Well, the part about autopsy examination and time of death begins on page 30, in which case it should be, the only thing that's really relevant to Detective Lang is the first page, 29.
Can I see it then?
Yeah.
I'm willing to agree to the redaction of the bottom quarter of page 38, beginning at examination of stomach contents, and the page 40 and 41, which would be 39 rather, the bottom of 39 and through page 41, because I don't think that those were used. To the extent that other sections were used to impeach, I would stand on the court's wisdom after reviewing the transcripts.
How do you impeach a detective with the examination of bodies to determine time of death?
All right.
I don't recall specifically what was done, so as I say, I'm not willing to concede that at this point.
All right, I'll look at 17,998. All right, but we do accept the concession to remove those last two pages.
Yes, Your Honor.
All right, 1053.
I think that's self-authenticating, Your Honor. There was a foundation objection, since she's been called as a witness. There can be no real sincere challenge to the accuracy of the photograph.
Submitted? All right. Objections withdrawn. Okay, 1055, my favorite objection. Maglite. Ms. Clarke.
For the record, Your Honor, 1054 was withdrawn.
Yes, I'm sorry, thank you. 1054 is withdrawn. Ms. Clarke.
Flashlight used. I can't even remember. Is it
Maglite.
Maglite? Oh, withdrawn.
Okay.
What was Could I see 1054?
1054 was that one-page fax from Mr. Coleman.
We withdrew.
Mr. Coleman?
It's been withdrawn with regard to Furman.
Oh, okay. Thank you. Okay.
Ring a bell? Okay.
Yeah.
Mr. Darden indicated yesterday he did not know if there was an objection to 1062, 63, 64, and 65, and he wanted the ability to re-inspect those items.
Right.
And they are available. Two of the items are here right now.
Clearly. Now, Your Honor.
Is
Be
the
my
golf bag
guest.
out?
I'm sorry?
Is the golf bag there? Golf bag, is that out there?
I don't think we brought the golf bag up.
I'll get somebody down to search him while you're
Mrs.
on the
Robertson
bench.
said where is it? It's in the closet.
Oh, that's fine. We could,
We'll
All
get
right,
some-
how
we'll
about
get
at, how about at a recess, we'll do that. All right.
For the record, the golf bag has been inventoried by the court's clerk at least twice, if I'm not mistaken.
As well as by the bailiff.
Correct.
All right. All right, 1066 has been withdrawn.
Correct, Your Honor.
All right, 1071. Crime Scene Field Unit Protocol and Procedures Manual. Ms. Clarke.
I think this is Mr. Goldberg, right?
I'm sorry.
Yes, this was the, good morning, Your Honor.
Good morning, Mr. Goldberg.
This is the black binder that contains the draft manual of the Los Angeles Police Department. I don't think it was recognized by Dennis Fung or Andrea Mazzola, but Greg Matheson and Michelle Kessler both testified that they did not recognize all the documents in there. They had not reviewed the entire manual. However, it was a draft manual, and I think both of them stated that there were certain things in the manual they disagreed with. So there is no authentication for it, and there is no exception to the hearsay rule.
Well, there's
HPS.
authentication for what it is.
Right.
Well, yeah, but I mean, the documents within it, they can't actually go through it and say that they recognize all of the documents within it even.
Matheson said that he put it together?
No.
No. Matheson testified that this was a manual that he was putting together for purposes of accreditation. I mean, the testimony, I think, is pretty clear from the witnesses. Some of them are handouts that some of them recognized, some weren't. Michelle Kessler said that she reviewed all of them. Some she agreed with, some she didn't necessarily agree with, that hadn't finished the process of finalizing it. I mean, it is what it is.
Actually, it was the supervisor of the trace unit, as counsel will recall, that was in the process of putting it together, and he stopped when that supervisor either left or was transferred. There was some testimony to that effect. Mr. Matheson was never personally putting this together, if that's what counsel's suggesting. I don't know if he is. But at any rate, the point is, to me, this isn't even arguable. There is no exception to the hearsay rule under which something that's not in effect comes in, and to which every page has, or every handout has not been authenticated.
The issue is, what is it being used for? I think that the issue in the case is they're running a lab with either without a manual or with a quasi-manual. Now, as we go through the list of these objections, there are
A
certain...
quasi-manual.
I'm sorry?
Never mind.
All right, yes. We're not... The fact that they have such a manual, and at various different points as we go through these objections, certain parts of this were used and I think are not objected to. Certain parts of it, I think everything that was used is not objected to. I may be wrong. Are there some others here that...
I thought there was only one, only one particular document, or two particular documents that I can recall being used from that. One was the protocol on how to collect blood, which we objected to. It was marked several times as a number of different exhibits. And the other one was an ancient memo from Chief Gates that I believe Michelle Kessler was asked about, and Mr. Darden also objected to that, or will object to that.
There's also a section on forensic photography on how to take pictures that was shown to some of the witnesses, and Mr. Regal testified about that. So it was used, to that extent, it was used for impeachment at various different times. I'm not... I don't understand, if the objection is that that is not what it purports to be, then I just don't think it's well taken.
All right. Court will sustain the objection under 352 because it is a draft manual and of little probative value.
If I understand, we can, of course, make references to the fact that they were shown this manual and they were impeached with it. You're not ruling out reference to the manual by any means as it appears in the transcript.
Not to their testimony, no.
No, the only thing
But
is
the
that
item
we
itself.
can't pull the manual out and start showing the jury pages that weren't shown to the witnesses.
But if you're smart in your argument, you won't get down to quibbling about the manual, will you?
Well, I think it's of some relevance that we have a crime lab that doesn't have a manual.
Your Honor, we're not making a motion to...
I've never
strike
heard of
that
a crime
testimony,
lab
so
like
there's
that.
no point of arguing about it.
Until I got here.
Because if you think quibbling about lines in the manual is going to persuade this jury one way or the other. All right, 1082.
Excuse me, Your
Oh,
Honor.
I'm sorry, 1078 is the next objection. This is the videotape of glove on a blanket.
Yeah, this was the famous blob that was on the blanket that we had extensive arguments about previously. I renew those arguments here. I don't care to restate them because I know that the court heard them at length previously. In addition to that, Your Honors, as we previously discussed yesterday, we were objecting to all of the videotapes conditionally upon redaction, and that would pertain to this as well, but I think we've basically agreed to that, the
All right.
procedure for handling that objection.
All right, the objection then is overruled, subject to the redaction of the portion that was used on that one. 1082, the objection is, any argument on that?
No, Your Honor.
All right, the objection is overruled subject to the redaction of, to the portion that was used. 1083,
It's no argument, Your Honor, the same.
all right. Objection will be overruled subject to the redaction to the point, to the portion that was used. All right, 1084,
Your Honor, this was the evidence collection sheet that I referred to previously in the last argument that I made. This particular one was shown to Dennis Fung. As I said, it was marked a couple of times. And Mr. Fung testified, let me get the page citation. I don't have personal knowledge of this, but I was told that Mr. Douglas indicated that there was no foundation for this, and they might be withdrawing this.
I can clear this up if you want, Your Honor. The 1084 is the 3-page handout dealing with how to collect the blood stain. It is also 1118. It was shown to Ms. Mazzola, and then it was even shown later to Michelle Kessler. See if I can get that reference. And that would be 1319. Now, when Dennis Fung was shown this, he, of course, couldn't remember seeing it before. When Ms. Mazzola was shown this, and this is at page 24396 at the transcript, she acknowledged that this was what she was given at the SID Mini Academy, that she was familiar with it as the handout on how to collect the blood stain. I would note that this is the same 3-page document that we were given by Fung and Mazzola at the split hearing on how to collect the blood stain. I'm fairly astonished that they can come in here and object to this on lack of authentication. It's just an absurdity. And then on 1319, that's the same exhibit, which is at page 42003 of the transcript. Kessler acknowledges this, and
Which page did you say?
I think it's 42, I'll check it for you, 42003 of the transcript. Comes up again, but I think it's admissible simply on the basis of Mazzola's testimony that, yes, she was familiar with this as the document that they handed out at the SID Mini Academy on how to collect the blood stain. It was up on the Elmo. It was the jury's seen it. And I suppose that for the sake of clarity, we could cross-reference them.
Well, Your Honor, these issues are really very simple. First of all, counsel's right. Mr. Fung did say that he hadn't seen it, so there's no authentication there. I'm not positive about Ms. Mazzola, because I hadn't recalled her having been asked about it. And Ms. Kessler was only asked one question about this document, and nothing as to whether it's a current policy. I mean, no authenticating type questions as to what it constitutes specifically. And I'm also looking at 42002. But there's a very simple way of resolving these issues, and that is that there's something called the hearsay rule, and we don't allow hearsay into court unless it qualifies under some exception. We do have exceptions for materials of this kind when you are cross-examining an expert witness under 1071, as I recall. We've argued this numerous times in the past, if they've read, relied, or considered this type of material. And then you don't get to introduce the underlying report, even then. Even if the witness says, yes, I recognize this and I relied on it, you simply get to ask them questions about it, because the underlying report is still hearsay. It is simply coming in under this evidence code provision for the purposes of testing the opinion and the underlying basis for the opinion of the witness. So you can cross-examine them on it, but you don't introduce the underlying document. So I don't see any hearsay rule exception to allow this in, any authentication for it under any one of those hearsay exceptions that they read, relied, or considered it. And at any rate, even if they were cross-examined on it, which they weren't, as to things in the pages that were inconsistent with what they did or whatever, which is not the case. But even if they had been cross-examined, the cross-examination would stand, but the underlying document itself would not come in.
Your Honor, at page 24396 of the transcript, question to Ms. Mazzola. This is in regard to 11-1118. Show you this, ask you to take a look at it. Item number 13, okay. Question by Mazzola, also look at that. Do these pages represent a handout you received at the SID Mini Academy? Yes, they look familiar. And in that handout, he goes on to discuss how they should collect the blood stain. There was extensive cross-examination about how you're supposed to collect the whole thing, particularly for purposes of RFLP analysis. This is the handout that they gave us on how they collect blood stains, which Mazzola authenticates and Kessler suggested and Fung forgot about. But there's no question as to what it is. It's not a hearsay problem here. This is their instructions on how to collect the blood stain. It's relevant for many different points. A, we impeach them on the fact that they didn't follow the procedure. Because if they followed their procedure, then they should have removed all the blood from the Bronco.
So if it's so simple, what's the evidence code exception for this document?
No, I'm saying that it's offered for impeachment. It is also a business record of the SID laboratory with respect to how to collect the blood stain that was given out to the criminalist as a record that she's supposed to follow. So in that respect, it's not even hearsay. It's being offered, well, it's a business record. It's being offered as a set of instructions on how they're supposed to go about collecting blood stains. It's offered for impeachment with respect to the techniques involved. And in contrast to other techniques, it also comes in as a document that's reasonably relied upon by experts in the field. These are their experts. These are the procedures that Mazzola at least acknowledged she's supposed to follow in the collection of blood evidence. So it comes in as a basis for her expert opinion as to how you're supposed to collect blood stains at a crime scene. So there's a number of different grounds to admit it. And I'm very surprised that they could object on authentication grounds, given the testimony in the record and the fact that they turned this over to us at a split hearing and in discovery as their methods for how to collect the blood stain.
All right, objections overruled. All right, 1095.
This was it's just simply a list of things that's supposed to be in the truck.
Yes.
And no one ever authenticated having seen it, and it doesn't have any relevance. It doesn't qualify under any hearsay exception. I'm not even sure the theory under which it's being offered.
Mr. Scheck?
The only problem here is with respect to the actual testimony, Mr. Fung said that he couldn't specifically recall seeing this form before, but he'd seen one like it with respect to what items are supposed to be in the crime scene truck. And this is the only document that they ever turned over to us as to the list of things that are supposed to be in the crime scene truck.
All right. The objection sustained. That was 1095. All right, 1101, 02, 03, and 04.
Those were the same objections that I previously made to the videos, Your Honor.
All right, those objections will be overruled, subject to the redaction of the portions that were actually displayed to the jury. All right, 1106 has been withdrawn. All right, 1115.
Is that the Gates?
No, it's just a one-page, starts with a quote from Ralph Waldo Emerson. All right, withdrawn. 116.
116,
I'm sorry, 1116.
go ahead.
That was 1115 that was withdrawn.
I'm not, 1116 is another one of the handouts to the field procedure, from the field procedures manual, as I recall. And we objected to that on hearsay, no authentication, and irrelevant grounds. I just want to check the transcript to... Mr. Neufeld can be heard, and maybe I'll just respond to him.
Your Honor, this has to do with what they're supposed to do with respect to photographs at the crime scene. And just like 1118, Ms. Mazzola did testify that they did receive a handout on forensic photography. She couldn't be sure that this was exactly the same one, but she did remember a two-page handout on forensic photography, and it certainly could be the same one. And for all the same reasons that Mr. Scheck already articulated for item 1118, I think they apply here with equal force. There's no difference other than the fact that she's not quite as absolutely certain. Short of that, I think the same degree of authentication has been established, and thus the foundation has been laid. 1 second. No, but if their objection is authentication, okay, I'm limiting myself to the authentication argument because obviously all the other arguments in terms of impeachment and a business record, all the arguments that Mr. Scheck already made would apply with equal force here, so there's no reason to restate them. So I'm assuming that their objection is limited to authentication. But on this document, unlike 1115, where we withdrew it because we agreed there was not sufficient authentication by the witness, here again there is the authentication by Ms. Mazzola.
The alleged authentication that counsel refers to on page 24-249 of the transcript, starting at line 11, is by Mr. Neufeld. Show you what has been marked as defendants 1116. Ask you to take a look at those 2 pages. Ms. Mazzola's 1116, defense 1116, the handout that you received on forensic photography. Answer, I don't know if it is the exact handout that we received. Question, could be. Answer, it's possible. I mean, that's the skimpiest authentication I think I've ever seen in a very long time.
The next 2 sentences, though, Your Honor, are...
That she does...
You said it could be...
Well, that she does... Counsel, if I
Well,
may.
you say you recall, you say you recall receiving a handout on forensic photography. Did you not answer yes? So that is the only handout. There is no...
Excuse me, counsel.
Sorry.
My recollection is Mr. Goldberg was addressing that.
So she received some handout, and she says it's possible that it could be this one. That just doesn't even come anywhere arguably close to being authentication. But also, I'd renew and restate the objections that I previously had. I mean, unless there's something inconsistent about this, or they've been cross-examined about it, yeah, possibly that cross-examination is admissible under 1071 of the evidence code.
All right.
But this should not be allowed.
No, the only point is that we received a group of handouts from the prosecution. This is the only handout on forensic photography. There isn't any other handout. If they were suggesting that there was another one, then I could understand that perhaps the authentication might not be adequate here. But if there's only one, and she said she did receive one, and this could be it, that should be adequate.
All right, the objection will be sustained on two grounds. One, authentication, and two, Mazzola wasn't the photographer. If you had asked these questions of Mr. Rokar, that would have been different. All right, number 1117. This is the prosecution videotape of the evidence collection demonstration.
Yes, Your Honor, we simply objected to the sound on that and asked that be redacted out pursuant to the court's previous rulings.
All right, then the objection is overruled, subject to the sound not being played during the course of if the jury wishes to see this video again. All right, 1118 we've already discussed. 1120. Is the report of a statement by Andrea Mazzola.
Yes, Your Honor, this was actually the subject of a previous court ruling where counsel wanted to cross-examine Ms. Mazzola about a interview that she had with DA investigators where they were asking her about a treatment for a book or a screenplay that someone had written to the effect that evidence had been planted. I don't know whether the court recalls that. It came up during Ms. Mazzola's testimony, and the court ruled that the court would not allow cross-examination on that subject matter. There was very limited cross-examination as to there being an interview and limited cross-examination, as I recall, as to whether or not she said something or other about the blood vial, and then she was shown this document and said she'd never seen it before, didn't recognize it. There's no authentication for it. There's no foundation for it. It's hearsay, and it should also be excluded under the court's previous rulings on this issue.
All right, objection sustained. All right, 1121.
That was the 1119 that we just discussed, I'm sorry. Yeah,
1121. What's the objection to 1121?
I didn't know, I didn't think it was objected to 1121.
All right. Then objection will be overruled to 1121. That's what I have for my notes from yesterday. All right, 1122, 1123. Mr. Goldberg, if you recollect, these
Yes.
are Elmo printouts.
Correct, and Mr. Douglas agreed that the prosecution could substitute original photographs for those.
Correct, Your Honor.
All right. That'll be the order. Madam Reporter will take a break in about 5 minutes. All right, 1132. Board. Mrs. Robertson, 1132.
Your Honor,
Mr. Goldberg.
this is a board that Greg Matheson was shown, and the discussion starts on page 25679 of the transcript. What it was intended to show was that 20 nanograms of DNA would be at the size of a pin, and that 2 nanograms would be invisible. Mr. Matheson never agreed with that proposition, although he was shown this diagram. And what he did say that makes it a little bit more confusing is that 20 nanograms of DNA contained in blood cells, in other words, the DNA had not been extracted out, is visible. And I think he may have even said that 2 nanograms of DNA in blood cells is visible. And what this is trying to indicate is the visibility of 20 nanograms and 2 nanograms of DNA outside of red blood, with the idea that it would be easily contaminated because you can't see it. But
What
this
is-
is a proposition to which he did not agree.
What is your page site?
My page site is that the discussion on this issue starts on 25/6/79.
All right.
And there's a particular discussion on 25/6/80, lines 2 through 16 that I highlighted as to what 20 nanograms looks like, et cetera.
Mr. Blasier?
Well, Dr. Cotton was also asked about this chart and testified at 27112, was used in a hypothetical about the amounts of DNA as indicated on the chart, hypothetically, if that had been injected or contaminated into the Bundy drops that had been degraded, that would give a positive RFLP result. So I think it's been authenticated through Dr. Cotton.
All right. I'll take that one under submission.
And
All
perhaps
right.
the court could read it would get the gist of the people's objection if the court read 25/6/80, the citation of the
All right. Let's see 1133, PCR amplification board. Mr. Goldberg?
Your Honor, this board and the next one were used also with Greg Matheson. And virtually what happened is they simply put the board up there and asked Mr. Matheson almost no questions about it whatsoever. They did ask Mr. Matheson that whether PCR amplification involved 32 cycles, which he agreed to. But as to the number that you end up with, the 4,290,000, he never agreed to that number. All he said is it would be a large number. So there is no authentication for this exhibit.
Looks like 4 billion to me.
Excuse me? Yes, right. Ms. Deidre was blocking off 3 of those zeros over there. But at any rate, the discussion for that, Your Honor, commences on page 25/685. And the most relevant portion is on 25/687, where he is asked, and typically that is done 32 times correct. That is the protocol of forensics, yes. Question, and that chart depicts that starting out with a very small amount and doubling it 30 times, I guess that's a mistake, leads to a very large amount, correct? Answer, double it 32, yes. It's an extremely large number, but there's no statement as to the specific number.
Well, I'm not sure if this is a new objection. This was objected to at the time on page 25688, and that objection was overruled by the court. But more importantly, Gary Sims testified about this chart specifically on, and I'll refer the court to pages 28416 and 28425, where he talked about this chart and the next, well, this chart, and authenticated that the concept that we were portraying there is accurate. And I'm not sure if they're suggesting that there's some sort of mathematical problem. They didn't bring that up, and I don't think there is.
All right, the objection's overruled. All right, number 1140, 3-page analyze evidence report. This will be the last matter we'll take up before we take a break. Certainly.
Could we see that one, I think?
Yeah, this is Mr. Matheson's,
Well, we also objected to 1134, Your Honor, which is the,
I know,
what?
objection's overruled.
If I could see 1140, I think we can.
I thought we were just discussing 1133.
We were discussing both of them. Do you want to be heard on 1134?
Maybe the court had already ruled on that. I don't know.
If you feel you need to say something specifically with regard, because it's the same mathematical process that it
No, I
depicts.
thought that the 1134, as I recall, shows a number of different overlying triangular
Yes.
patterns. And I don't know whether that was used with Garrison's or not, Your Honor. But at any rate, on this particular one, this one was put up simultaneously to Greg Mathison's testimony, but they didn't ask him any questions about it. He wasn't asked, what does this show, or do you agree with it, or, I mean, there was nothing in the way of authentication.
Mr. Blasier?
It was just simultaneously shown to his testimony.
He authenticated this at 25688 without objection from the prosecution in terms of the concept that's being displayed here about when you amplify DNA, different types are going to get amplified as well, and Gary Sims talked about this extensively.
We see the kind of loose language that's being used. You've authenticated the concept here. The discussion of this starts on page 42049, and it was shown. Oh, I'm sorry. It starts on 25688, and it was put up there, but there were no questions about it.
No, he was asked questions about, isn't it accurate that if you've got several different components of a mixture and the amplification is done, they all get amplified and you wind up with a lot of each one of them. And this is just 4 times what's on the last chart.
I mean, I just think there's to be some authentication for the correctness of these numbers. And to my knowledge, no one has said these numbers are correct. I mean, maybe they are. I don't know. I have no idea. But I don't think there's anything in the record
Gary,
that the numbers are correct.
yes.
All right. Objections overruled. All right, 1140.
1140, I think the
I'm
problem...
sorry, I didn't hear the court's rule.
Overruled.
1140, I think the problem there was the second page was, the court redacted parts of that. And,
Well, this same document was marked by the prosecution and may have been redacted in a different way. But for some reason, counsel's cut out the results on 117, 118A, and 118B.
well, that was...
I don't know why.
That was because the court would not allow them to go into the 117 after that. I can't remember the exact reason, but it was because they had not raised it in their direct, I believe. And they were trying to make an argument after they were done.
But as I recall, what happened was Mr. Sims then testified based upon Mr. Mathison's report what the conventional serology results were on the rear gate stains for the purposes showing that there was degradation.
So you have
on
no
those
objection
stains.
to the complete report, is that what you're saying?
Uh,
Which is already a prosecution exhibit?
Yes.
All right, then what we'll do is withdraw, since the complete report is, do you know, can you give me the cross-reference number on that?
I can't do it right now, Your Honor. But
All
I
right,
can provide you.
then what I propose then is that we withdraw the defense exhibit, since it is a redacted copy, and substitute in its place the complete copy. Any objection to that?
Yeah, the only problem with that is I think the prosecution's exhibit is missing that page. That's my recollection as to why I introduced...
All right, well, since we both agree that we need the complete report, we'll get the complete report, we'll substitute it in both locations. How's that?
That's fine.
Okay, we'll do that. Okay, let's take a 15-minute recess, and we'll resume with 11:43. All right, back on the record. 11:43.
Your Honor, this was the series of printouts that were to portray the EAP issue, where the prosecution said that yesterday we didn't have any objection other than those we previously argued at the time, other than that the resolution on some of these is poor. The actual photographs are all in evidence anyway. And maybe if there's some sort of admonition or some way of letting the jurors know that they can take a look at the actual photographs from the EAP runs where the resolution is significantly different, materially different than on the Elmo.
Well, these weren't put on the Elmo, these are PowerPoint slides.
Yep.
I have no objection to them being told that there are pictures of these if they need to look at them. I would object to them being told that the pictures are much better than the slides. I mean, the slides are there to illustrate where the bands are and in their relative positions, and they do that quite well.
All right, but they have available to them, what is available to them, though, is pretty clear to my eye.
Yeah.
So, all right. And then that objection will be overruled. All right, number 1145.
Good morning, Your Honor.
Mr. Clarke, how are you?
Just fine, thank you. The court may recall there was a substantial argument over this exhibit, and the court sustained objections on multiple grounds.
Many times.
Yes. That is also Exhibit 1205, by the way. It is indeed the same exhibit.
All right. All right. Objection sustained. 1154.
Objection to that item, and that again was used with multiple witnesses, is hearsay and no foundation. This was a letter from CACLD to Cellmark. And the court sustained those objections at the time as well.
Didn't Dr. Cotton, though, testify to this at some point?
Actually,
All right, so let me just get the basis for the objection.
Hearsay and no foundation.
Your Honor, if you look at the transcript, initially they objected not to, on the foundation hearsay grounds, and the court ruled that my questionings for the foundation were inadequate. And then you called me over to a sidebar, you instructed me on how to complete the foundation. I came back, I completed the foundation using questions that the court suggested. Mr. Clarke again objected, and you overruled the objection, and you at that point let it in. If you look at page, beginning at, looks like it's 257, oh, I'm sorry, 27502, 275. 27501. In fact, the 27502, he again renews the objection after I laid the additional foundation that the court suggested, and that's when you overruled the objection and allowed me to publish the exhibit.
All right. Is the matter submitted?
Yes.
All right, objection's overruled. All right, 1158 is being withdrawn.
For purposes of clarification, that is the same as 1191B. If that's going to be offered by the defense, then we have no intention of moving in 1158, but I think we need to clarify that.
Is the DQ alpha types of funding Mazzola? Is that what we're talking about?
Yes. Actually, and polymarker as well.
We'll it was done outside the presence of the jury, but we'll move it in by stipulation if you want, that's no problem.
1191A and B are coming in, then the withdrawal of 1158 is adequate.
Okay.
I don't know about 1191 yet.
All right, 1170.
Your Honor, how are you?
Mr. Harmon, how are you?
Fine, thank you.
Still got the beard.
Just taking after other bearded gentlemen around here. Every objection was sustained to that which there was no testimony about that. Mr. Sims expressed no expertise in it. You agreed that it was beyond the scope of the testimony. And so while they succeeded in getting it marked, that was the extent of it, Your Honor.
This is what, 2.8, this is...
1170?
1170.
That's Cellmark's polymarker strip.
Cellmark's polymarker on the steering wheel. Mr. Sims looked at it, said he was familiar with it, but said he would not venture an opinion on it. It, however, is the same, the underlying polymarker that was used for the results on the steering wheel that was introduced through Robin Cotton. I mean, this is the polymarker strip that they used. So I don't
Is it in
understand how
evidence?
he's objecting on lack of authentication.
Is it in evidence someplace else, under a different?
Well, Mr. Clarke...
Can I answer that, Your Honor?
Mr. Clarke did not offer the strip itself. He offered the results on their results board based on their underlying data. So if they're saying there's no authentication for this, I don't see how they got half the evidence in this case in the first place. I don't understand how he can sit up here and object to the polymarker strip that they gave us that's the basis of one of their results.
Well, the problem is we've got an exhibit, and the testimony about the exhibit indicates an inadequate foundation.
That's not accurate. What it states is that he says he is familiar with this as the polymarker strip from the steering wheel. He then goes on to say that he does not want to draw any judgments from it because he doesn't feel sufficiently familiar or expert with the polymarker. That's different from saying it shouldn't come into evidence. I mean, he's objecting on lack of authentication to a result he put in. I mean, this is frivolous.
To answer the question you asked him that he never answered, the strips are not in evidence. They were never shown to anybody in front of this jury in this case, and I've never objected on the basis of no authentication. So I objected, and the transcript is clear. He never answered any question. You sustained objections that it was beyond the scope of his direct examination. So while it's great to mark things, and while it is true that is in fact Cellmark's strip, we do have rules. They're called the California Evidence Code, which dictate what the jury can see and in what form they can see it in. And it's simply us asking you to apply the rules.
That's not, Mr. Harmon is not stating accurately. The court can look at itself at the transcript at page 28683. Mr. Sims said he was familiar with this strip. Then, when he indicated that he didn't feel competent to make an opinion about the strip, objections were sustained to my going any further with it. Now, that's different. As to whether he's conceded, I showed him this, he said, yes, that's the strip.
All right.
I'm not sure it's a big deal, but the point is that as a legal basis, it's admissible. As to striking any further testimony, he said in terms of his ability to read polymarker strips, well, that's another thing that's already been done.
All right, 1183.
With respect to 1183 and 1184, 1183, and we can check this, I think is the same thing you just dealt with on 1154 and 1155. These are the California Association of Crime Lab Directors report and the Cellmark letter in regard to the blind trials. 1184, I believe, is the Thompson article about the CACLD study, and we withdraw 1184.
All right,
If I'm right about what those things are.
Yes, you are. This is 1184. It's Doc Thompson's article.
Yeah, so 1183 I think is in, and 1184 we withdraw.
All right, any other comment on that?
Yes, 1183 isn't in. The exhibit that was shown to Dr. Cotton is in. And if you look at the testimony of Colin Yamuchi, he was asked if he'd seen that, and he said no. And so 1183, as it exists, should not be admitted in this case.
I think what we ought to do, as we've done before, is cross-reference them so the jury knows that the whole point of it is that he didn't know about it. And we're talking about the same set of documents. That is, the report from the California Association of Crime Lab Directors, and the Cellmark letter. Our point concerning their false positive errors.
All right. What we'll do is cross-reference this. Okay, 1191B, which I think is a duplicate of 1158, if I'm not mistaken. This is the Fung and Mazzola D1S80.
Mr. Clarke says he's looked at it, and subject to his representations and checking it, we have no objections to 1191A, well, 1191A and B are supposed to be, if you put them together, the D1S80, DQ alpha, and polymarker genotypes for Fung and Mazzola, right?
Well, and other personnel.
So if that's what it is, that's fine with us.
Okay. Mr. Clarke? $1191A, no objection?
Could we see that quickly?
All right, Mr. Clarke, Mr. Harmon, what's your status on these? Actually, 1191 and 1192, excuse me, 1191A and B.
No objection.
All right. All right, the record should reflect that Exhibit 1195 has been withdrawn. Exhibit 1197, 98, 99, 1200, and 1201 likewise have been withdrawn. All right, next matter that's contested is 1205. The letter. Submitted? Sustained. All right, 1207 has been withdrawn. 1215 is the Amplitype User's Guide.
The only objection is to the material other than was what was used with the witness regarding the 1.2 mixtures.
Mr. Neufeld, Mr. Scheck?
I'm sorry.
On 1215, the Amplitype User's Guide, there's no objection to the paragraph that was used. However, there's an objection to the extraneous material.
I'm sorry, this has to do with the mix, is that right?
Yes.
I think that's fine.
It's not a paragraph, though. It's actually a couple of pages that deal with it. And certainly to the extent that it only deals with the mixture and the 1.2 problem, we'll so limit it.
All right. All right, then I'll overrule the objection subject to the redaction for that purpose. All right, refresh my recollection. Who handled Mr. Diedrich?
I did.
All right, 1220.
Do you have that physically, Ron?
I'm sorry, Your Honor, do you also have our, do you also have a note that we withdrew certain exhibits?
I'm
From
sorry.
yesterday, informally, we withdrew certain exhibits.
Yes.
For Bruce Weir. You've already
Yes.
so indicated?
Yeah, we went through that about 3 minutes ago.
Oh, all right. Thanks.
Okay. All right, Ms. Clarke, as to 1220.
Right. The objection is that there's no relevance to it. That was a system of classification of hairs and fibers not used by Mr. Diedrich, nor was it shown that it was used by any witness or expert for the defense. It's a system of classification of characteristics that assigns numerical values or assigns a number to each of the various characteristics for the purpose of attempting to categorize, but there was no foundation laid to establish that it's an accepted procedure in the scientific community at all. In fact, to the contrary, Mr. Diedrich rejected it.
Mr.
Well,
Blasier.
he did testify that he remembered reading, he disagreed with the numbering system, that's accurate, but he agreed that the list of characteristics that were described on there are characteristics that he looks at. I would submit it on that.
I'll overrule the objection on that one. All right, 1221.
Your Honor, you skipped 1217. You're overruling that objection on 1220?
Yes.
There was no foundation laid
12.
by the defense, Your Honor.
Counsel, I've heard the argument. There was no objection lodged to 1217.
It is in my list.
It was,
Mr. Cochran?
it's a worksheet, isn't it?
Mm-hmm.
When we went through this yesterday, this was not on the list, but
It's in my August 7th letter.
I agree it was, but yesterday they didn't have it on the list. I'm happy to deal with it.
All right, 1217.
That was irrelevant. That was a worksheet marked by Susan Brockbank, but did not involve any of the evidence she testified to.
It was an example of the worksheet that they used to classify hairs. That's what it was intended for. I agree it was not any hair that was used in this case. That was why I introduced it as an example of how they classify hairs. There was no objection to it at the time. She authenticated, this is the form we use.
All right, the objection's overruled. All right, 1221. Twelve 21 indicates that it's one page, appears to have 2 pages.
I'm not sure why page 2 is there. It shouldn't be.
It appears to be, Mr. Blasier, it appears to be your notes.
Now, this obviously is second page.
Well, B and C you probably want.
Well, yeah, we can cut off the bottom part.
All right, Ms. Clarke. All right, you withdraw the objection subject to the cutting off of the bottom.
Yes.
All right. 1221. And I'll staple the 2 parts together so they don't get lost. All right, 1222, FBI Hair Guide.
I need a page cite on that. See.
182, line 11. Just
Sure. You want to see this?
I know what it Maybe I don't. Are you holding it? Oh, this is yellow. Which one?
All right, 1226 has been withdrawn. I'm sorry? All right. That'll be sustained. Okay, 1233. This is Mandel and Aronson.
Interject, Your Honor. People's Defense 1227. Mr. Darden wanted to interpose an objection to that photograph.
That's the photograph of the defendant in
The night before.
the night before. We'd object on the same grounds as earlier this morning with regard to 1003. The defendant posing for a photograph, in our opinion, has no probative value. It's misleading to the jury.
Smith.
All right, objection is overruled. All right, 1233. We might as well take up 1233 and 1234, same time.
I have a discrepancy here. I interposed an objection to 1233 that was described to me as an article on the selection of non-correlated thin layer chromatography,
All right.
chromatographic solvent.
No, 1233 is the printout of Ellen Aronson's route from her apartment to the Mezzaluna restaurant, 1234 being the route back.
Your Honor, then we've skipped a couple of the objections I needed to have on the Diedrich exhibits because I had them they were misnumbered in my version, 1223 and 1224. I had objections to. They were misnumbered in my.
Okay, well, let me do this. Since I've got these out, 1223 and 1234, do you have any objections to these?
Oh, those routes. No.
This
No.
is here, Aronson and...
Right.
Okay.
No objection.
All right, let's go back then. You want to go back to 1223
Yeah, I'm sorry, Your Honor.
and 1224?
Mm-hmm.
All right, 1223 is the, appears to be the Golding and Cocotte, K-O-K-O-T article. Golding.
Is it entitled The Selection of Non-Correlated Thin Layer Chromatographic Solvent?
That's it.
Okay. Yeah, there'd be an objection to that, Your Honor, as being hearsay, irrelevant. There was no foundation. It was an article shown to Mr. Diedrich that he did not, I believe, demonstrate familiarity with. There was no adoption of it. There was no reliance on it, nor was it even impeaching.
Can I take a look at it, because that wasn't on my list?
All right, withdrawn. 1224 is the... Thank you.
respect to, should I put on the almost so I can talk to you and we can see it at the same time?
All right, familiar with it.
Okay. On the,
Why don't you use the microphone so the court reporter can get you? Ms. Clarke.
I'm just waiting for Mr. Blasier so he can hear my objections. First of all, with respect to all of these slides, they're argumentative, and they should not be admitted as evidence. If they wanted to use them as argument boards, I think that would be fine. Secondly, with respect to the gloves, the gloves board in particular, board or slide in particular, is incorrect. It said that there is no hair consistent with O.J. Simpson on the Rockingham glove. That's incorrect. There is a black limb hair that would be consistent with Mr. Simpson. That is consistent with Mr. Simpson, rather, in the testimony of Doug Diedrich.
All right, so the only factual inaccuracy, or as far as the record is concerned, is which one of the slides? The Rockingham glove slide?
Yeah, actually, it's a both gloves slide. That's incorrect.
What's the other inaccuracy?
It's all on one slide. The
I see.
slide's entitled Both Gloves. And it's incorrect with respect to the assertion on the Rockingham glove.
Any other factual inaccuracies that you're alleging?
No.
All right, Mr. Blasier?
I think we went through this when this was shown. I believe the testimony was that they don't classify limb hairs. And certainly this, they can say it's negroid, but that's all. And I don't believe that he testified that, as with the other hairs with other characteristics, that he's willing to make any kind of assessment on this one. But we went through this at the time this was shown and introduced. And,
There's a distinction between how definitive he could be in his conclusion with respect to limb hairs versus head hairs, because head hairs have more characteristics. But it is correct that the limb hair found inside the Rockingham glove is consistent with limb hairs of with having come from Mr. Simpson. So this is a misleading assertion on this slide.
I don't think he ever said that. And I know this was discussed by Mr. Bailey, because I think the issue came up at the time that we used that. And I believe there was even a bench conference about it, where the court allowed it on the basis that they don't classify limb hairs, even though they can tell the race, that that's not the same as head hairs, where they have a lot of other characteristics to look at. That's my recollection.
See, I don't remember what the bench conference was, Your Honor. I just know that, given the witness's testimony, that the limb hair in the Rockingham glove could have come from Mr. Simpson. In view of that testimony, it's misleading to say no hair consistent with him.
Do we have any reference in the transcript where this is discussed?
We're going to have to dig it up, Your Honor. It would be right in there. It'll be right in there.
I'm almost positive this has been covered. Do we pass on this one?
Yeah, let's pass on it for now, and I'll pull the, it'll be volume
Scheck,
181.
Mr. Scheck says he's got it.
Well, we've got the reference to the number, but I'm not sure that's what we're looking for. I can find it.
Okay. All right, 1235. Thank you.
What is the date of this statement, Your Honor?
I'm sorry, the date of this statement?
Right. It says Statement of Ellen Aronson,
Yes, it is.
and is that, okay, that's, yeah, July 8th.
This is a subsequent telephonic July 8.
Interview with Detective Kilcoyne.
Yes.
And the people's objection to that would be hearsay?
I think, Your Honor, it's offered to rebut a claim of recent fabrication. It also has sufficient guarantees of trustworthiness. I believe, although I'm not certain, this was offered on redirect after there had been a spirited cross-examination about some of the times, the confusions about the hours on the Metzalina clock, whether or not she had recalled accurately what times she had left, and the substance of a subsequent conversation with the detective when she sought to correct misinformation that she'd been given earlier. So I think for these reasons it's admissible.
Well, my list of exhibits that I have in front of me doesn't show it, but was her initial police report admitted in the statement she gave on June 15th?
I don't believe so.
It wasn't offered.
Oh, yes, it was marked by the people. The point being, Your Honor, that this would not be admissible under that theory unless the people had marked and admitted her initial statement as a prior inconsistent statement.
No, I think that if you attack somebody's testimony at trial, then the offering party can bring in a prior consistent statement.
But it doesn't qualify as a prior consistent statement because it was not previous to the inconsistent statement. You know what I'm saying?
What?
Yeah, I mean,
know what
I
you're saying.
think that it was, it sounded confusing to me. But she made a prior inconsistent statement on June the 15th. That was her initial statement. She then changed it after the preliminary hearing on July the 8th. So that was the statement that was consistent with her testimony at trial. It doesn't qualify. It's not prior in time to the inconsistent statement.
It's consistent with what she said on direct. She was then impeached on cross-examination, and she offered a prior consistent statement to what she said on direct.
That doesn't satisfy 1235 or 770, Your Honor. That doesn't meet the requirements. It's got to be prior in time to the inconsistent.
All right, 1236 of the Evidence Code says evidence of a statement previously made by a witness is not made inadmissible by the hearsay rule if the statement is consistent with his or her testimony at the hearing and is offered in compliance with Section 791. Thank you. And Ms. Clarke, just so you can cross-reference your own records, the prior statement that was put in by the people as People's Exhibit 495 is the June 15th statement of Ms. Aronson. So there are under 1236 and 791, I'm going to overrule your objections. Okay.
Back to 1234. I found the page in the transcript where that was all discussed.
All right, give me the page number, please.
35340. Same objections were made and they were overruled.
Okay, 1237. I'm sorry.
What was the, I missed it.
35340 was the page site on,
Okay.
we'll come back to that. All right, 1236.
What was the objection, 1236?
I show in my notes the objection to 1236 and 1237.
I see 1236, Your Honor.
1236 is the September 12th
Interview by-
statement by Aronson.
September 12th, that statement doesn't qualify. Under 791, I mean, it's the same problem. The evidence of a statement made that is inconsistent, that has been admitted, the prior consistent statement has to have been made before the alleged inconsistent statement, which was on June the 15th, which obviously it was not. Secondly, before the motive to fabricate has arisen. And the people's position clearly is that this was a groupie who wanted to get herself injected in the trial, and that motive existed at the time that she recontacted Detective Kilcoyne and realized it was going to be a very high-profile case, which was on July 8th, and she began to restructure her testimony to make sure that it would be relevant. That's the motive. Now, September 12th certainly is not prior to that time, nor is it prior to the June 15th prior inconsistent statement. And the people submit that it does not qualify under 791.
Submit on the earlier comments, Your Honor. I think the rulings are consistent.
All right, objection's overruled. 1237, phone bill. Ms. Clarke.
Hearsay and irrelevant.
Well, Your Honor, certainly I think it's very relevant because it helped to explain why Ms. Pilnuck was certain that various acts occurred at different times. I think that it is, in fact, a bill from the phone company. We have been introducing these sorts of documents by stipulation and other forms. I don't think that there is any sincere challenge to the authenticity of the bill. I think it offers sufficient guarantees of trustworthiness for its admissibility. But she was, as you will recall, she was very exact in recounting what events occurred at certain times, when she called her mother, when Ms. Thielander had left, and that bill corroborated the specificity with which she offered her testimony.
My recollection is that she testified that this was her phone bill.
Correct.
All right, the objection will be overruled. All right, 1240.
Hearsay objection.
That objection, well, the document, Your Honor, was offered to demonstrate Mr. Heidstra's state of mind that when there was an occasion with he and other witnesses to recount and to go through various observations from June the 13th, that there was, in fact, his state of mind not to discuss with other potential witnesses. It reinforced our claim that he was not biased, that he was not polluted by the presence or potential testimony of others, particularly with Mr. Heidstra. That has become a very real challenge. I'll simply remind the court that, as far as I understand, 4 of the first 8 names that we were given of rebuttal witnesses were witnesses seeking to rebut Mr. Heidstra. His credibility, his bias, if any, are therefore rising themselves in importance, at least from the people's version of the evidence, and this supports or attacks any suggestion that when we tried to gather people together to go over certain steps and observations, that there was no polluting.
No, it's not relevant for that purpose. It's a letter from Mr. Bailey to Mr. Heidstra. I don't know how that impacts on, that illuminates us as to Mr. Heidstra's frame of mind or his veracity or credibility at all.
All right, thank you, counsel. The objection sustained. All right, 12:50.
I'm sorry, Your Honor, we have to add 1241. It was inadvertently left off of our list. It's a two-page statement of Mr. Heidstra.
And I'll offer the same comments and adopt those comments that I offered as respect to Ms. Aronson. Again, Mr. Heistra's credibility will be viciously attacked, strongly attacked. I don't want to characterize it. And this is a prior consistent statement offered to rebut a claim of recent fabrication that he is fabricating at this hearing when he testified as he did.
I can assure the court that Mr. Heidstra's credibility will not be attacked viciously. In fact, we think Mr. Heidstra's testimony is very helpful to the prosecution. And in fact, what we intend to do is buttress Mr. Heidstra's testimony. Still, however, it is hearsay. It is an out-of-court statement. It was alluded to somewhat during the trial. That is what he had said previously, and he testified on the stand to what he had stated previously.